Finding new customers can be a real challenge for businesses operating across global markets that are driven by mass production and low margins. However, those businesses that can start a dialogue with consumers have a chance to understand their specific needs and meet these. This can help build brand loyalty and ultimately deliver that competitive edge. We're seeing more customers adopting customer relationship marketing or CRM systems to help manage the dialogue with their customers. This trend is supported by research that suggests the worldwide CRM software market grew 12.5% in 2012. The technology allows businesses to learn more about customers and to target communications that speak to them as individuals, not just as a demographic. However, using a person's data to communicate with them raises important data protection challenges. The UK regulator of data protection, the Information Commissioner, reported a 43% increase in the number of complaints about electronic marketing in 2012, and this included calls, emails, text, and awareness research by his own office in 2013 revealed high levels of public concern about unsolicited marketing approaches.
European data protection laws set out a framework of principles. In the UK, this exists as 8 core principles, and this is a starting point around how to make sure that any use of customer data for marketing purposes is done lawfully. There is no outright prohibition on such activity, but you have to observe the rules, otherwise your use of contact details in this way becomes unlawful. On the one hand, there is a data protection law that is based on an EU directive. That includes a general duty to process people's data fairly. So this means making sure that people understand that they may receive marketing information from a business and that they're agreeing to this. Marketing rules also give people a right to be exercised at any time to tell a business to stop using their details for marketing purposes. On the other hand, these marketing rules are also about considering how to reach out to people, whether that's by post, email, voice calls, mobile text messages, and also it's about complying with further channel-specific rules that form an additional layer of EU data protection and marketing law.
What we mean by direct marketing is promotional activity directed at a particular person. This can be through any channel, and it doesn't have to be about selling products or services. It can also cover other promotional approaches, including fundraising or political campaigning. It's important to remember here that purely service communications would not be seen as direct marketing. This would cover, for example, the email confirmation of an order or a delivery update. But if a service message included any promotional element, such as an invitation to order again, then this would be treated as direct marketing. Areas where we are seeing the regulator being particularly active are in enforcing rules around electronic marketing, including email, text and voice calls. His office can issue fines, among other sanctions, for persistent offenders, the most recent being for £50,000 against an energy services company in the third quarter of 2013, and this was for making unsolicited calls to hundreds of individuals. The rules that apply to direct marketing by email, mobile text and voice calls are quite detailed, but they can be summarised in the following way. With email, the default requirement is that unsolicited email marketing should only be directed to a consumer who's first given their permission. There's an exception to this rule where, firstly, the person's details are collected in the course of a purchase or negotiations to purchase a product or a service. Secondly, that the subsequent marketing is only of the business's own similar products and services. And lastly, that at the point of collection, the person is given an opportunity to refuse the marketing, and there's an unsubscribe in all future marketing emails that they receive. These rules also apply to mobile text marketing messages, but not to email or text messages that might go to an employee of an organisation using their work and email address. With telephone marketing, the general rule in the UK is not to call any number registered with the statutory stop file, which is the telephone preference service. This is unless the person who gets the bill has said they don't object to receiving calls from the business.
Online and behavioural advertising uses information about browsing behaviour to target advertising to specific individuals, and typically this uses cookies or similar technologies. This information may not directly identify a person in the same way as their email address may do, but it means that they can be recognised, that they can be tracked and they can be targeted. And for this reason, Cookies and similar technologies are covered by EU data protection laws. A key consideration here is transparency and engagement with consumers by first providing prominent and user-friendly information about the cookies and technology so that they can understand what is going on and make informed choices about what they do or don't want to happen. And second, and most importantly, by getting the user's consent.
The rules for OBA across Europe are broadly similar, however, there are subtle differences that can mean different practical solutions may be required. For example, the difference between an opt-in or an opt-out, depending on different country interpretations of what constitutes valid consent. It's ultimately about being more transparent with consumers, giving them clear, prominent information and offering choices. Only by being clear and upfront with people can a business foster consumer trust, a willingness by people to enter into dialogue with business and ultimately to divulge their information.